In the fall of 2021, on a flat stretch of high plains land in western Nebraska, a 78-year-old man stood in the middle of his own cornfield and watched strangers kill it. Not with fire, not with flood, with silence. A single valve, buried 4 feet underground, was shut by a man in a company vest who did not know the farmer's name and did not ask. Within 6 hours, 400 acres of corn that had been 11 days from harvest began to die of thirst. The man who owned that field, Walter Kroeger, did not shout. He did not call the sheriff. He walked back to his truck, opened the glove box, and took out a folder of papers so old the staples had rusted orange into the pages. He had been carrying that folder for 40 years, waiting, without quite knowing it, for the day someone would force him to use it. What the company had just done, believing it was clearing an obstacle, was in fact triggering a legal claim buried in Nebraska water law since 1887. A claim older than the state highway that ran past the farm, older than the company that had just tried to erase it, and worth, by the time a jury finished counting, more than the company had budgeted for the entire project. If you believe that the land remembers who worked it, hit subscribe. We tell stories about ordinary people who face extraordinary injustice and come out the other side standing. And before you go further, drop a comment and tell us where you're watching from. These stories travel farther than we ever expect. Walter Kroeger did not think of himself as a stubborn man, though everyone in Chalk County would have used that word first. He thought of himself as a careful one. There is a difference, he liked to say, between refusing to change and refusing to change for the wrong reasons. He had farmed the same 640 acres outside the town of Dell Junction for 51 years, ever since his father, Ansel Kroeger, had signed the deed over to him in 1970 with a single instruction: never let the water rights lapse. Walter had not understood at 27 why his father repeated that sentence 3 times. He understood it fully only much later, and by then it had saved his life's work. The Kroeger homestead traced back to 1886 when Walter's great-grandfather, a Volga-German immigrant named Johann Kroeger, filed a claim on the land under the Homestead Act, and a year later filed something almost nobody else in the county bothered with: a formal appropriation of water rights from the Lostwood Creek, a slow spring-fed tributary that ran along the eastern edge of the property. In the arid high plains, water was worth more than the land itself, and the men who understood that early were the men whose families survived the droughts of the 1930s and the 1950s, while their neighbors sold out and left. Johann Kroeger's filing, dated April 3, 1887, established what water law calls a senior appropriative right, first in time, first in right. It meant that in any year of shortage, the Kroeger farm's claim to Lostwood Creek water came before almost every other user on the stream, because almost no one else had filed that early. Walter grew up hearing his father talk about the old paper, the way other families talked about scripture. It sat for decades in a fireproof box in the farmhouse, alongside the original homestead patent and a black and white photograph of Johann Kroeger standing beside a hand-dug irrigation ditch, with an expression that suggested he already understood what he had built. Walter had the document properly recorded with the Nebraska Department of Natural Resources in 1974, after a lawyer in Scottsbluff advised him that a poorly maintained filing was as good as no filing at all. He kept meticulous diversion logs from that year forward, how many acre-feet he pulled from the creek on what dates for what crops. He was by nature a man who wrote things down. He farmed corn and dry edible beans, rotating fields to preserve the soil, and in later years added a modest herd of black Angus cattle that grazed the creek bottom in the off-season. He was not wealthy by any outside measure, but he was solvent, self-sufficient, and known throughout the county as a man whose handshake was better than most contracts. He had married Louise Bergman in 1968, she had passed in 2015, and since then Walter had farmed largely alone. With seasonal help from a neighbor's grandson, and increasingly from his own granddaughter Emily Kroeger Voss, who had grown up spending summers on the farm and had gone on to law school in Lincoln, a fact that would matter more than anyone yet understood. Walter was not a man who resisted progress for its own sake. He had modernized his pivot irrigation system in 2009, installed soil moisture sensors in 2016, and even leased a small corner of his land to a cell tower company in 2011 without complaint, because the tower did not touch his water. What he could not abide, and what he had told anyone who asked for 30 years, was anyone treating the creek as though it belonged to whoever showed up last with the most money. "The water doesn't care how big your company is," he told a county commissioner once at a public meeting about a proposed reservoir upstream. "It cares who filed first." Nobody in that room, including Walter, could have predicted that within a decade those words would be tested in a courtroom. In the spring of 2020, a Denver-based renewable energy developer called Meridian Sable Partners began quietly acquiring easements across a 15-mile corridor of western Nebraska farmland. Their plan was ambitious and on paper beneficial to the region: a combined solar array and battery storage facility, along with a transmission spur connecting to the regional grid, designed to serve a data center campus under construction near North Platte. The project promised jobs, tax revenue, and a foothold in a state eager to diversify its energy base. Meridian Sable's land team worked efficiently, moving parcel by parcel, offering competitive easement payments to landowners along the corridor. Their maps showed that the most efficient route for both the transmission line and a planned groundwater recharge basin, an engineered pond meant to help cool the battery facility and support local aquifer levels. A green energy feature the company was proud of, crossed directly through the low-lying eastern quarter of the Kroeger farm, precisely where Lostwood Creek ran, and where Walter's senior diversion point had sat largely unchanged since 1887. Meridian Sable's surveyors identified the creek. What they did not do, according to records that would later surface in discovery, was pull the full adjudicated water rights history for that stretch of stream. Their environmental consultant's report treated Lostwood Creek as an unappropriated or lightly used waterway, suitable for a recharge basin that would, by necessity, alter and partially impound its flow. A company land agent named Craig Delmer visited Walter in June of 2020 with an easement offer, a one-time payment for a permanent right-of-way across 40 acres, plus the recharge basin footprint. Walter read the offer carefully, as he read everything, and then told Craig Delmer something the younger man clearly had not expected to hear from a farmer in a feed cap. "You're proposing to dam my creek," Walter said. "I hold the senior right on that water going back to 1887. You impound it, you're not leasing land from me. You're taking water I own the first claim to, and Nebraska law is going to have opinions about that." Delmer, by his own later deposition testimony, assumed this was a negotiating tactic, an old farmer trying to drive up the price. He relayed to his supervisors that the landowner was difficult and recommended the company pursue an alternate legal avenue if negotiations stalled. Negotiations did stall. Walter's attorney, a semi-retired Scottsbluff practitioner named Douglas Fenn, who had represented 3 generations of Chalk County ranchers, sent Meridian Sable a formal notice in August 2020 asserting the senior appropriative right and demanding the company revise its basin design to avoid impounding creek flow above Walter's diversion point. He included a certified copy of the 1887 filing and the 1974 recordation. Meridian Sable's in-house counsel responded 2 months later with a letter stating the company believed its project would not materially interfere with any existing water rights and that construction would proceed as scheduled. Citing project financing deadlines tied to a federal tax credit that would expire if the recharge basin was not operational by a certain date. It was the same posture companies so often take when they have already decided that the cost of proceeding is lower than the cost of waiting. Move first, litigate later if you have to. Emily Voss, Walter's granddaughter, was in her 4th year practicing law in Lincoln when her grandfather called to tell her what was happening. She was not yet a water law specialist. Her practice at the time centered on general civil litigation, but she understood immediately that this was not an ordinary boundary dispute. "Grandpa," she told him over the phone, "do not sign anything, and do not let anyone touch that creek without a court order." Walter told her he had no intention of signing anything. What neither of them yet knew was that Meridian Sable did not intend to wait for one. Construction on the transmission corridor began in early September 2021. Meridian Sable's crews worked methodically west to east, and by the last week of September they had reached the boundary of the Kroeger property. Walter's corn was 11 days from harvest, a crop he had nursed through a dry July with careful, rationed irrigation pulled from his senior right on Lostwood Creek, exactly as his diversion log for that year would later show. On September 27th, without notice to Walter. Without a court order and without a completed environmental permit for the recharge basin, a fact that would become central to the case, a Meridian Sable construction crew installed a temporary diversion structure upstream of Walter's intake, redirecting the creek's flow into a staging pond to support grading work for the battery facility's foundation. Walter's irrigation pivot, which drew water from a headgate fed directly by Lostwood Creek, went dry within hours. He noticed the pressure drop that afternoon while checking his soil sensors and drove the 4 miles to his diversion point, where he found the creek reduced to a damp streambed and a temporary earthen berm, built with company equipment, redirecting what water remained. A construction foreman on site, a man named Rick Osa, who was simply following the day's work order, told Walter the diversion was authorized under the company's easement and would be temporary, a few weeks at most. Walter told him it wouldn't take a few weeks. It would take about 11 days, which was exactly how long his corn had left before the yield loss became irreversible, and by day 6 the damage was already visible in the leaf curl across 400 acres. He called Craig Delmer. He called the company's regional office. He called the Nebraska Department of Natural Resources, whose regional water commissioner, a man named Terrence Whitlock, who had spent 19 years enforcing appropriation priorities in the district, drove out the next morning, walked the streambed, and confirmed on the spot that the diversion violated Walter's senior right and that the company had no emergency authorization to impound or redirect flow. Whitlock issued a formal cease and desist notice to Meridian Sable that same afternoon, ordering the temporary structure removed within 24 hours. The company complied, but 24 hours at the tail end of a dry September was enough. By the time water reached Walter's headgate again, the corn had crossed a threshold no amount of late irrigation could reverse. He watched over the following 2 weeks, as leaves that should have been thickening toward harvest instead yellowed and dropped, ear by ear, row by row, across the same fields his great-grandfather had first watered from that same creek 134 years earlier. What made the moment harder to absorb, Walter would later testify, was not the crop loss alone. Corn farmers live with weather every year and loss was not new to him. It was the manner of it. Nobody from Meridian Sable had walked onto his land and asked. Nobody had looked at the folder of papers he had kept in a fireproof box his entire adult life. A valve had simply been turned by a man who did not know his name. On the theory, later admitted in a company memo produced during discovery, that landowner objections in this segment are not expected to materially delay the schedule. Walter drove home that evening, sat at his kitchen table, and for the first time in 6 years since Louise had passed, called Emily and told her he needed her professionally, not just as family. If you want to see how this story turns, and it turns hard, stay with us. Because what Emily found in the State Water Archive 3 weeks later is the reason this case ended up rewriting how Nebraska regulators treat renewable energy projects crossing senior water rights. Subscribe now so you don't miss the verdict and tell us in the comments. Have you ever watched something you built taken from you by people who never bothered to ask? Emily Voss took an unpaid leave from her firm in October 2021 and moved back into her grandmother's old sewing room at the farmhouse for 6 weeks, converting the kitchen table into a workspace covered in certified copies hydrology reports and a laptop permanently open to the Nebraska Department of Natural Resources online water rights database. She was joined, at Douglas Fenn's recommendation, by a Lincoln-based water law specialist named Renata Ibarra, who had litigated appropriation disputes across 3 states, and who took the case in part because she recognized immediately how unusual and well-documented Walter's claim was. Most senior water rights cases in the region turned on partial or ambiguous historical records. Walter's did not. Johann Kroeger's 1887 filing was complete, properly witnessed, and had been continuously and diligently exercised, meaning the water had actually been put to beneficial use year after year without interruption for over a century. Under prior appropriation doctrine, that combination of an early filing date and unbroken beneficial use is close to the strongest water right a landowner can hold. Renata Ibarra's first move was to obtain Meridian Sable's own permitting file through a public records request to the county, and what it contained surprised even her. The company's environmental consultant had indeed flagged Lostwood Creek in an early-stage report. But a later internal revision, dated 4 months before construction began, had reclassified the creek's water rights status from requires further verification to no known senior appropriations of record. A characterization Ibarra could not reconcile with the fact that the 1974 recordation was a matter of public record searchable in the same state database Ibarra herself had used in under 10 minutes. In depositions, the consultant who authored the revision could not explain the change, and eventually testified that the reclassification had been made after a phone call with a Meridian Sable project manager, who wanted the water issue resolved so the timeline could move forward. That single admission would become one of the most damaging pieces of evidence in the case, because it suggested not an honest oversight but a decision to proceed despite unresolved risk. Meanwhile, Emily and a hired agricultural economist, Dr. Priya Malhotra from the University of Nebraska's Agricultural Extension Program worked to quantify what the 11-day water loss had actually cost. It was not simply the value of the ruined corn, though that alone came to a significant 6-figure sum across 400 acres. Dr. Malhotra's report went further, documenting soil compaction from the temporary diversion berm, damage to the creek bank ecosystem that supported Walter's cattle grazing rotation, and critically, a diminishment in the appraised value of the water right itself. A senior appropriative right of this age and reliability, Dr. Malhotra's report explained, carried independent market value in a region where water scarcity was intensifying. A demonstrated willingness by a large developer to disregard that right, even temporarily, created a documented cloud on its reliability that a future buyer or lender would rightly discount. It was an argument few juries had heard framed so precisely before, and it would prove decisive. Walter, for his part, spent that autumn doing something he found almost unbearable: waiting. He was a man used to solving problems with his hands, and this problem required him to sit at a kitchen table and answer questions from lawyers instead. But he did one thing that mattered as much as any legal filing. He kept farming. He replanted a winter cover crop on the damaged acreage that November, refusing to let the land sit scarred and empty through the case, telling Emily that whatever the court decided, the ground still has to be looked after in the meantime. It was Renata Ibarra would later say. One of the most persuasive things about him as a witness, that even mid-lawsuit mid-injury he behaved exactly like a man for whom the land was not an asset in a filing, but a responsibility he had inherited and intended to pass on. Meridian Sable partners did not settle quickly, and their resistance was not irrational from a corporate standpoint. The tax credit deadline tied to the recharge basin's completion date meant that any admission of fault carrying a construction delay could jeopardize financing across the entire 15-mile project, not just the segment crossing Kroeger land. The company's outside counsel, a large regional firm out of Omaha, filed a motion in early 2022 arguing that Walter's 1887 filing, while facially valid, had never been formally adjudicated in a general stream adjudication proceeding, and that without such an adjudication, the priority date could not be conclusively established against a competing claimant, namely Meridian Sable's own newly filed industrial water use permit for the recharge basin submitted in late 2021 after construction had already damaged Walter's crop. It was a technical argument, but not a frivolous one, and for several tense months it threatened to unravel the strength of Walter's position. Nebraska's water rights system, unlike some western states, had never completed a comprehensive adjudication of every tributary in the district, meaning thousands of older filings across the state existed in a kind of respected but not judicially confirmed status. Renata Ibarra's response was to request an expedited stream adjudication specific to the Lostwood Creek segment, a rarely used but available procedure, forcing the Department of Natural Resources itself to formally rule on priority among all claimants on that stretch of water. Terrence Whitlock's office, whose original cease and desist notice already reflected the department's operational view that Walter held priority, conducted the formal review over the following 4 months, examining Johann Kroeger's original 1887 filing alongside 7 other claims on the creek. In June 2022, the department issued its formal adjudication order, confirming the Kroeger appropriation as the senior right on Lostwood Creek by a margin of over 2 decades against the next oldest claimant, and confirming that Meridian Sable's 2021 permit application was, by definition, junior to it. The adjudication did not end the case. It strengthened Walter's civil claim for damages, but Meridian Sable's attorneys pivoted their defense toward disputing the extent of harm rather than the underlying right. They brought in their own hydrologist, who argued the 11-day diversion viewed against a full growing season represented a minor and largely recoverable interruption, and their own agricultural expert, who offered a substantially lower damage estimate than Dr. Malhotra's, attributing much of the crop loss to the region's below-average July rainfall rather than the September diversion. It set up what Douglas Fenn described to Walter, only half joking, as a fight over how much a shut valve costs when the man who shut it insists the sky was already doing most of the work. The company also. In a move that surprised no one who had watched large developers handle disputes before, attempted a private approach. In August 2022, a senior Meridian Sable executive contacted Walter directly outside the presence of counsel, offering a settlement figure well below what Renata Ibarra's damage models supported. Framed as a good neighbor resolution, intended to let both parties move forward. Walter, polite as always, told the executive he would need to discuss it with his attorney before responding to anything, and then called Emily the moment he hung up the phone. The offer, once relayed through counsel, was formally rejected. It was the last serious settlement attempt before the case proceeded to trial. The trial opened in the Chalk County District Court in March 2023 and lasted 8 days. Drawing more public attention than any civil case the county had seen in a generation, partly because it touched a subject every farmer and rancher in the region understood in their bones. Water was the one resource nobody in that country could pretend not to care about. Walter testified on the 3rd day. He brought, at Renata Ibarra's request, the original fireproof box, not for evidentiary purposes since certified copies had already been entered, but because Ibarra wanted the jury to see physically what 4 generations of careful stewardship looked like. He answered questions about diversion logs stretching back decades, about the winter he lost a third of his crop to a bad decision he made himself, and learned from about the cattle rotation along the creek bottom. About the morning he found the creek reduced to a damp streambed 11 days before harvest. Dr. Priya Malhotra testified to her damage calculations across 2 full days, walking the jury through crop loss, soil compaction, remediation costs. The diminished market value of a senior water right, whose reliability had been publicly disregarded by a well-resourced developer, and the long-term cost of restoring the creek bank ecosystem disturbed by the temporary berm. Terrence Whitlock testified as a state regulatory witness, confirming both the department's cease and desist finding and the subsequent formal adjudication establishing Walter's priority. Perhaps most damaging to the defense, the environmental consultant, whose report had quietly reclassified the creek's water rights status, was called to the stand. under Renata Ibarra's cross-examination, could not offer a technical justification for the change that did not trace back to a phone call requesting the timeline be protected. Meridian Sable's defense rested heavily on its own hydrologist and agricultural expert, along with testimony from Craig Delmer, who maintained under oath that Walter had never clearly communicated the legal basis of his objection during their initial 2020 meeting. Testimony Douglas Fenn, undercut simply by reading Delmer's own contemporaneous email to his supervisors back to him, an email in which Delmer had written weeks before construction began, that the landowner cited an 1887 senior water right and provided a copy of the filing. The company's closing argument leaned on the framing that had guided its posture from the start, that a fast-moving renewable energy project serving a genuine public benefit should not be derailed by a dispute over 11 days of water, and that whatever harm occurred was modest, partially caused by weather and already remedied by the department's cease and desist order. The jury did not agree. After a day and a half of deliberation, they returned a verdict in Walter's favor on every count: breach of statutory water rights, negligent interference with a real property interest, and based on the internal memo and the reclassified consultant report, a finding of willful disregard sufficient to support punitive damages under Nebraska law. The total judgment came to $4.1 million, covering crop and soil damages, diminished water right value, ecosystem restoration costs, and a punitive component, the jury explained in a note handed to the judge, was meant to reflect that a company that can read a filing and chooses not to should not be treated the same as one that genuinely couldn't have known. Walter Kroeger was 79 years old when the verdict came down, and true to the man his neighbors had always known, his first public statement outside the courthouse was not about the money at all. He told the small cluster of regional reporters waiting on the courthouse steps that he hoped the case would make the next company think twice before shutting a valve on land they hadn't fully understood. He put a significant portion of the judgment into an irrevocable trust that permanently protected the Kroeger senior water right from ever being leased, sold, or diminished, ensuring that whoever farmed that land after him, and he had already begun preparing Emily's younger brother Nathan, who had expressed interest in taking over the operation, would inherit the same certainty Johann Kroeger had fought to establish in 1887. A portion funded a full ecological restoration of the creek bank and the compacted grading area work that took most of 2023 and 2024, and that Walter, despite his age, insisted on supervising, personally walking the restoration crew's progress most mornings, with the same soil moisture sensors he'd used for years, now repurposed to monitor the healing land. He also established a modest scholarship at the county's agricultural extension program in Louise's name, aimed specifically at young people studying water resource management. A quiet acknowledgement, Emily said later, that the case had only succeeded because someone in the family had understood both farming and law well enough to connect them. Meridian Sable Partners, for its part, redesigned the recharge basin to sit entirely upstream of Walter's diversion point, a modification that added cost and months to the project, but ultimately allowed construction to resume without further legal exposure. The company's public statements framed the outcome as a resolution that allows the project to move forward responsibly. Though internal policy changes that followed, new mandatory water rights verification protocols across all Meridian Sable projects nationwide told a more candid story about what the case had actually taught the organization. Terrence Whitlock's department cited the Kroeger adjudication in subsequent guidance issued to renewable energy developers statewide, urging early and thorough water rights verification before any project touching a tributary stream advanced past the design phase. Farmers and water attorneys across 3 states would cite the case for years afterward. By the fall of 2024, the corn was back. Not the same corn, not the same 11 days of growth lost forever, but a full crop on the eastern quarter, drawn from a creek running clean and undiverted past a restored bank thick with native grass. Walter walked those rows most evenings that September, the way he had for 50 years, checking leaf color, checking soil, occasionally pulling an ear to test its fill. Nathan worked alongside him more now, learning the rotations, learning the diversion log, and Emily, though her practice had moved permanently toward water law after the case, still came out most weekends, less as counsel now and more simply as family. There is a truth that experienced farmers and ranchers across the arid West understand instinctively, even when they rarely say it aloud. The most valuable thing on a piece of land is often something you cannot see from the road. It is not the fence line or the pivot or even the crop standing in the field in August. It is the paperwork filed a century and a half ago by a man who could not have known what it would someday be worth, kept faithfully by every generation after him, not because they expected to need it, but because letting it lapse felt in some inherited and unspoken way like a betrayal of the ones who came before. Walter Kroeger did not win his case because he was lucky, and he did not win it because a company happened to make an obvious mistake. He won it because for 134 years, someone in his family had always kept the water accounted for, the diversion logs, the recordation, the careful, boring, unglamorous discipline of writing down what was used, and when year after year, long after anyone thought it would matter. Aldo Leopold the conservationist who spent his career studying land in exactly this part of the country once wrote that we abuse land because we regard it as a commodity belonging to us, and that when we begin to see it as a community to which we belong, we may begin to use it with love and respect. Walter Kroeger never read those words aloud to a courtroom. He did not need to. Every diversion log in that fireproof box said it for him. The creek runs clean again past the Kroeger farm today, past a young stand of corn and a restored bank thick with native grass, into a battery facility that finally learned to take a piece of paper seriously. What was almost lost in a single afternoon of quiet, careless efficiency took 3 years, and a folder no one thought to check to fully restore. That is the part of this story worth sitting with. If this story moved you, let us know in the comments. Has your family ever held onto something for generations that turned out to matter more than anyone expected? And if you want to see more stories about ordinary people who outprepared the systems that tried to take from them, subscribe and stay with us. There are more of these stories to tell.